Imagine it's Monday morning and you've just made the decision to terminate an employee. You walk into their office, deliver the news, and by Wednesday, you're receiving a letter from their attorney alleging wrongful termination. Does that sound familiar? If you're nodding your head right now, you're not alone. Despite Florida being in an at-will employment state, thousands of employers find themselves in legal hot water every year simply because they didn't follow proper termination procedures. Let me introduce myself. I'm Santiago Cueto, a board-certified international business law expert and best-selling author who has spent nearly 3 decades helping businesses navigate the complex waters of employment law. I've seen companies lose hundreds of thousands of dollars in settlements and litigation costs, not because they didn't have the right to fire someone, but because they didn't fire them the right way. Today, I'm going to share with you the essential framework for properly terminating an employee in Florida while protecting your business from costly legal challenges. Let's dive in. Florida operates under what we call at-will employment, which means you can terminate an employee at any time with or without cause and with or without notice. It sounds simple, right? Well, here's where many employers get tripped up. While you have broad termination rights, there are significant exceptions that can turn a routine firing into a legal nightmare. The key thing to understand is that at will doesn't mean at whim. You cannot terminate someone for illegal reasons, and this is where most wrongful termination lawsuits originate. Under both Florida and federal law, you cannot fire someone based on discriminatory reasons. Additionally, you cannot retaliate against employees who file discrimination complaints, report safety violations, or engage in other protected activities. Here's a real-world example that illustrates this perfectly. Just last year, Nestle Waters North America paid $300,000 to settle a lawsuit where they terminated the only female zone manager during a consolidation, despite her 20 years of experience, while promoting a less qualified male. The lesson? Even legitimate business restructuring can become problematic if the pattern appears discriminatory. Before you ever think about terminating someone, you need to establish a solid documentation foundation. This isn't just good practice, it's your legal shield. Every performance issue, every policy violation, every coaching conversation should be documented contemporaneously. I'm talking about specific dates, specific incidents, and specific corrective actions taken. Your documentation should tell a clear story that demonstrates you gave the employee fair notice of problems and reasonable opportunities to improve. This means implementing a progressive disciplinary process where appropriate. Start with verbal warnings, move to written warnings, consider performance improvement plans, and document every step along the way. Remember, in Florida, you must maintain personnel records for at least 3 years and employment tax records for 4 years. This documentation becomes crucial if you face a wrongful termination claim because the burden will be on you to prove your termination was for legitimate, non-discriminatory reasons. Before you pull the trigger on any termination, conduct what I call a pre-termination risk assessment. Ask yourself 3 critical questions. First, does the employee belong to any protected class? Second, have they recently engaged in any protected activity like filing a complaint or taking FMLA leave? Third, are there any patterns in your termination decisions that could suggest discrimination? And fourth, have you followed your own company policies and procedures? This assessment isn't about finding reasons not to terminate, it's about identifying potential legal risks, ensuring you can articulate legitimate business reasons for your decision. If you identify red flags during this assessment, don't abandon the termination, but consider consulting with an employment counsel before proceeding. Also, review any employment contracts or collective bargaining agreements that might modify the at-will relationship. Some employees may have a contractual protection that requires specific termination procedures or advance notice. When it comes to the actual termination meeting, preparation is everything. This conversation should be brief, direct, and professional. Schedule the meeting for early in the week, preferably Tuesday through Thursday and early in the day. This gives employees time to process the information and handle practical matters before the weekend. Having at least 2 management representatives present, typically the employee's direct supervisor and an HR representative. Prepare a brief script that clearly communicates the decision and the business reasons behind it. Avoid lengthy explanations or getting drawn into debates about the decision. The termination meeting is not the time for performance coaching or giving the employee one more chance. Here's what you should cover: the decision to terminate, the effective date, information about final pay, benefits continuation options, return of company property, and any post-employment obligations. Keep the tone professional but empathetic. Remember, even if this termination is justified, it's still a significant life event for the employee. Your responsibilities don't end when the employee walks out the door, though. You need to handle several immediate post-termination actions to protect your business and comply with legal requirements. First, secure the workplace. Immediately disable the employee's access to computer systems, change passwords, and retrieve company property, including laptops, phones, keys, and access cards. If the employee had access to sensitive information or client relationships, consider whether additional protective measures are necessary. Second, handle the final paycheck properly. While Florida doesn't require immediate payment, you must pay all earned wages by the next regularly scheduled payday. This includes accrued vacation time if your company policy provides for payout upon termination. Third, if the employee was subject to an income withholding order for child support, you must promptly notify the appropriate child support agency of the termination. Now, after the termination, create a comprehensive termination file that includes the termination letter, documentation of the reasons for termination, records of the termination meeting, and confirmation of final pay and benefit information provided to the employee. The termination letter should be factual and concise, stating the termination date and basic information about final pay and benefits. Avoid detailed explanations of the reasons for termination in writing, as these documents can be used against you in litigation if they're not carefully crafted. Let me share some of the most common mistakes I see employers make. First, failing to follow their own policies. If your employee handbook outlines a progressive disciplinary process, you generally need to follow it even in an at-will state. Inconsistent application of policies can create discrimination claims. Second, terminating employees shortly after they engage in protected activity. Even if you have legitimate reasons for the termination, the timing can create an inference of retaliation. If you must terminate someone who recently filed a complaint or took medical leave, be prepared to clearly articulate and document your legitimate business reasons for that. Third, making statements during the termination that could be interpreted as discriminatory. Avoid comments about the employee's age, family situation, or any protected characteristics. Stick to job-related performance or conduct issues. Fourth, failing to conduct adequate investigations before terminating for misconduct. If you're terminating someone for violations of workplace policies, make sure you've conducted a fair and thorough investigation. Document your findings and give the employee an opportunity to respond to allegations when appropriate. Properly terminating an employee in Florida requires balancing your at-will rights with legal compliance and risk management. The key is preparation, documentation, and following consistent processes that demonstrate fairness and business justification. Remember, the goal isn't just to avoid lawsuits, it's to maintain a workplace culture that values fairness and professionalism. When employees see that terminations are handled respectfully and for legitimate business reasons, it actually enhances rather than undermines workplace morale and productivity. My final recommendation is this: when in doubt, consult with an employment counsel before making termination decisions that present unusual circumstances or elevated risks. The cost of a brief consultation is minimal compared to the potential cost of wrongful termination litigation. The most successful businesses I work with view proper termination procedures not as legal obstacles, but as essential business practices that protect their most valuable asset, their reputation as fair and professional employers. If you found this information valuable, please subscribe to my YouTube channel for more practical insights for business leaders, and don't forget to hit that like button to help other business owners discover this content. Remember, in employment law, an ounce of prevention is worth a pound of litigation. See you in the next one.